Good evening. Welcome in Delhi UPSC Editorial audio program. An ordinance, its constitutionality and scrutiny. The Hindu. The Union of India is unlikely to succeed in resting power of services in Delhi if the government of National Capital Territory of Delhi Amendment Ordinance 2023 is challenged. Biswajit Bhattacharya is a senior advocate in the Supreme Court of India and a former Additional Solicitor General of India. On May 19, 2023, the President of India exercised legislative power under Article 123 of the Constitution. During the period, Parliament was in recess to promulgate the Government of National Capital Territory of Delhi Amendment Ordinance 2023 Ordinance. The ordinance negates a constitution bench judgment of the Supreme Court of India, which was delivered on May 11, that brought services under the Government of National Capital Territory of Delhi (NCTD). Key issues: there are two issues here that require analysis. First, the scope of the court's verdict. Second, the constitutionality of the ordinance. While interpreting Article 239 AA 3A, the court ruled inter alia that these were the points. The Legislative Assembly of the NCTD has competence over entries in list second and third, except for expressly excluded entries of list second. Entries 1 to 18 are excluded, and the executive power of NCTD is coextensive extensive with its legislative power. That is, it shall extend to all matters with respect to which it has power to legislate. The Union of India has executive power only over three entries in list second, over which the NCTT does not have legislative competence. Entries 1 to 18. Thus, essentially, the court interpreted that out of the 66 entities in list second, the state list, while the executive power of the government of NCTD covered 63 entities entries that of the Union of India restricted to the remaining three: public order entry 1, police entry 2, and land entry 18. Consequently, executive power over services entry 41 can be exercised exclusively by the government of the NCTD. This interpretation of the court is consistent with the wordings in Article 239 AA 3A, but this interpretation was neglected by the Union of India, acting through its Council of Ministers under Article 74, by triggering extraordinary legislative power of the President under Article 123 in the promulgation of an ordinance of May 19. What uh, what the ordinance did was to read insert entry 41 of list second state list into Article 239 AA 3A, thereby expanding the scope of accepted matter from 3 1 to 18 to 4 1 to 1 to 1841. This could not have been done without amending Article 239 AA 3A of the Constitution. The power conferred on Parliament under Article 239 AA 3B is to make fresh laws, not to amend Article 239 AA 3A of the Constitution. Alteration needs and amendments. Similarly, power conferred on Parliament under Article 239 AA 7A is to make laws for giving effect to or supplementing the provisions contained in various clauses of Article 239 AA, and for all matters incidental or consequential thereto. Such a power cannot be pressed into action to amend Article 239 AA 3A of the Constitution. Significantly, Article 239 AA 7B stipulates that Parliament's lawmaking under Article 239 AA 7A shall not be deemed to be an amendment of the Constitution for the purposes of Article 368. No such clause has been stipulated in Article 239 AA 3A. Therefore, Altering the scope of Article 239 AA 3A requires constitutional amendment under Article 368. There is not an iota of doubt. Consequently, the ordinance promulgated under Article 123 of the Constitution to expand the scope of accepted matters in Article 239 AA 3A is void ab initio and is liable to be struck down for bypassing constitutional amendment. It amounts to a colorable exercise of power. Article 123 is no substitute for Article 368 amendment of the Constitution in Part XX 20. Besides, when the Constitution bench, five judges of the Supreme Court declares interprets the law, Article 239 AA 3A of the same is binding on all courts and authorities in India in terms of Article 141 and 144 respectively. Could Article 141 and 144 have been negated by Article 123 without a constitutional amendment? Article 123, 141, 144 in the Part V, Part 5, the Union of the Constitution, none has a non-obstante clause. The aid and advice of the Union Council of Ministers to the President under Article 74 could not have overridden Article 144. The basis of the court judgment is Article 239 AA 3A. To alter this basis, a constitutional amendment is necessary. A perspective, the Union of India's decision to prefer review Article 137 and promulgate an ordinance Article 123 simultaneously is ill-conceived. If the ordinance is challenged, the Union of India is unlikely to succeed through either route to wrest power of services in Delhi. In the landmark seven-judge bench verdict of the Supreme Court in the matter of Krishna Kumar Singh versus State of Bihar 2017 to SCC 136, the court held that the satisfaction of the president under Article 123 is not immune from judicial scrutiny. Powers under Article 123 is not a parallel source of lawmaking or an independent legislative authority. It was further held that the court is empowered to look into the relevance of material placed before the president, but not its sufficiency or adequacy. The ordinance is likely to be struck down since it expands accepted matters in Article 239 AA 3A. Parliament alone can do this under Article 368. Thank you.